talks about how really about 85% of cases resolve somewhere before a trial. They don't actually.
How do I know whether I can handle a legal matter myself?
And I said, well, they're still a trained killer. That's the way I look at it. And they went to law school and they have a law degree, and they're still going to beat you up in a courtroom if you don't have a lawyer.
What is like the main mistake that you see? If someone just took a piece of paper and started
His client
writing.
said, well, wait a minute, the court is closed at 6:30 a.m. And he said, exactly. So why are you calling me at 9 o'clock on a Saturday night?
Happy Tuesday evening, everybody. This is Kay Abigail Jones. I am here for the Weekly Law Roundup tonight as your guest host with the fabulous Steve Gillman. We're going to bend his ear tonight. You are listening to the Weekly Law Roundup on Praise 96.3. Like always, feel free to call into the studio or text your questions. You can text those and call in at 865-577-4885. Again, 865-577-4885. And then all week, if you have any sort of legal questions that you would like us to address on air, feel free to email those to theweeklylawroundup@gmail.com. Just squish it all together, theweeklylawroundup@gmail.com. All right. Nice to have you.
Well, look at that. You're a radio personality in addition to being a fine lawyer.
I try, but glad to have you on the show today.
Thank you for having me. So.
All right. Well, I guess we're just going to jump right in. I guess tell our lovely listeners how you got started in law, and just give a little backstory.
Sure. So I got started in law. I went to law school at the University of Tennessee, and went to undergrad there. So it felt like I was just there for 7 years. The first graduation didn't seem to matter since you just walk across the street. But I got started in the practice of law with Bob Pryor and Tim Priest and the attorneys at Pryor, Priest, and Harber. I started over there. So I actually, there's a little prehistory. I actually started out as a clerk with Jim Milligan, who was a personal injury lawyer. And I worked there for a few years. And I was taught by Bob Pryor in law school. We had the advocacy track, which they probably still have at the University of Tennessee, where it was learning how to practice law, getting on your feet in a courtroom. Yeah. And Bob helped start that at UT because he felt like there wasn't enough of that in the classroom with the practicality of practicing law, which is totally different, as you know, from law school.
Oh, yeah.
And so I was in Bob's class, and so I literally decided I wanted to have a change and do something different. So I started going around downtown and putting my application in and saw Bob's law. So I was taught by Bob. So I went up there and gave him my resume, and he wanted to meet with me. So I was in your class, and he goes, oh, yeah. And he said, you're in luck. And I said, oh, really? And he goes, oh, yeah. He said, our clerk that we had just took a job in Nashville. And so you got the job. Like it was he remembered me from class and all that. So, and he said, the bad news is for the next 2 weeks, we're doing renovations. You're going to have to move furniture. So I moved furniture for the first 2 weeks of being a law clerk. And that ended up turning into a legal job. Which was great because Bob and Tim, John Harber, all those guys, and then Robbie and Chris and Adam, I just got to learn from the best people, and that was invaluable. So
yeah, it absolutely sounds like it. But moving furniture, that's
yeah,
that's a rough
you got to pay your dues. Yeah, I mean, I 2 weeks just moving, no legal work, just moving furniture. And Frank Flynn was there at the time. He ended up passing away about 2 years later. He was kind of a Knoxville legend. I was talking to James H. Bill here. You're for stories of Bob and of course we share some lineage, our legal lineage, where Bill Banks, who worked with your father for years with the bank,
yes.
the Banks and Jones, used to way back in the day work with Tim Priest before Tim and Bob got together, and Bob was with James H. Bell, who's here. So we share legal ancestry there.
Very nice. So. I'm going to need to draw a flow chart, a big family tree.
Yeah, and they have lots of stories to tell us, as you know. So.
Oh yeah, I go. I love hearing all the stories. They're my favorite. Okay, so you joined Pryor, Priest, and Harber in 2003.
Yes.
Okay. What since then have you seen change the most about law practice in general?
So, it's interesting. I was actually talking before I came in here with some of your folks here about that. I think a couple of changes. Technology is probably the common sense answer. That's changed the practice of law so much, even though a lot of people maybe are slow to embrace it. But I think in general, the interactions with lawyers seem different. And by that I mean I feel like there's lawyers don't get together as much outside the practice of law as some of those stories you hear from Bob and from Tim and have that rapport. And there's more lawyers, so it's harder to do that, obviously. I think another thing that is a big deal is we see a lot more attorneys who are coming out of law school and they're just, as the old phrase, hanging a shingle, which is the old phrase of just going out and starting practicing law.
Yep.
Out of their house by themselves, and they don't have mentorship. You were lucky to be in a firm with your dad and have all that mentorship ever been here. I was very lucky to have that. But a lot of lawyers, as you know, you're dealing with are just thrown out there into the mix, and they don't have any mentorship.
That is sink or swim, unfortunately.
Yeah.
But, we do our best.
Yeah.
And I am very grateful to be where I am and have had my dad mentor. So, I can only imagine how valuable that was for you.
Yeah, for sure.
So I guess let's talk practice areas.
Yeah. So I do kind of a mix of things. I do wills and estates is probably the primary. Family law, as you know.
I do.
We've had some cases together. And then general business practice, or general practice of a lot of small businesses that wouldn't have counsel in-house. They're small enough, but they just need someone when something happens to call and say, what do I do with this? I have a collections matter. I have a contract to review. And so I do a lot of that, which is good. And I've been lucky to be able to do that. And then conservatorships and things that fall kind of in the wills and estates side of things. So
Okay. So I'm interested in the small business stuff.
Yeah.
So
which is a lot of crazy stuff that just
I can only imagine if it's all across the board. So does that include like if there was like a premises liability claim or just anything under the sun?
Yeah, so initially, if they're, for instance, with a lot of them, they'll call me and say, well, like a premises liability, that this happened, what do we do? And a lot of what it is saying, hey, get some pictures, get some statements, call your insurance company, because a lot of times they'll have insurance, and they're going to give them a free lawyer. So I'm just getting them in the initial phase to get to the right person, because most of them would have insurance, obviously. And the same thing if they were to call me and say, we've got all this debt and all these problems, I give them to a bankruptcy lawyer. But at least I can sit there and say, okay, what's going on? So they at least have someone to call when something comes up where they don't know where to go, which is important, as you all do. It's like if you don't do it, you'll get them to the right person who's going to do a good job for them. So.
Yeah, always try to help people out, send them in the right direction if we can, find somebody that can help.
Right,
so,
that's right.
Okay, so you also mentioned wills and estate planning. So I guess we have a lot of questions, so I'm just going to go through those kind of rapid fire. Okay, so we'll start with a family law question.
All right.
Our
favorite kind.
How important is mediation in family law?
Well, it's it's basically, and I do some mediation as well in that area, and so always when you go in there, everyone talks about how really about 85% of cases resolve somewhere before a trial. They don't actually go to trial. Everybody thinks that when you file a divorce, you're going straight to a trial, and really mediation, which is where people get together and work it out, as you know, is where most cases get resolved because it's costly to go to trial and you have risk. A judge gets a 1 day, if you're lucky, 2 day snapshot of your entire life. But in mediation, those parties and their lawyers know everything there is to know and can get really creative. So you have a lot of cases get resolved, and the judges will send you to mediation if you don't go voluntarily because they know how important that process and how often it gets cases worked out. So if we didn't have that, I think that we'd be waiting 3 years to get a trial date because there's so many trials. So.
What is your longest mediation?
I had a mediation. I think the longest I've had was we got there about 8 in the morning. We didn't finish up till about 7:30 at night, which was a long day. And yeah, you do get to a point where you feel like you're being waterboarded a little bit. So you have to take breaks, and because it's intense, especially for your client, because this is their life, especially family law, So
very emotional.
Yeah.
And we have a comment from your usual host, T. Scott Jones, saying that he is tuning in from Middle Tennessee. He had to go off to handle an ABOTA event, which is the American Board of Trial Advocates. So, just jealous. He gets to go have all the fun, but we're having fun here.
Yeah, he's down there listening to music, right?
Oh yeah, all the live music.
Yeah.
All right, so I guess we're just gonna jump around.
Sure.
What is the difference between having a will and having a trust?
So a will is, when you draft a will, it's a document that says how you want your your assets to be distributed at the time of your death. And so that document can be changed, can be modified, but it doesn't really become effective until you die. Whereas a trust, if you set up a trust, you do that in your lifetime. And so that is a vehicle, almost like a business, where you can put assets in that trust, and then the trust doesn't die. If you pass away, the trust has terms on how those assets will be distributed, or if the trust will just continue post-death. And so it's kind of a present-day way to set up your assets to where you can avoid probate. And then, of course, you get into specialized trusts that are important. Special needs trusts, if a child's disabled, then that child's assets can be protected by a trust so they don't lose benefits when they turn 18. And there's some other special reasons, but it's a present-day way to do estate planning or to situate things where it's almost like being put in a business that has a tax return and everything else, whereas a will doesn't really kick in until death, and that's if you have non-probate or if you have probate assets, your will would handle that if it's something that didn't pass otherwise. So.
Okay. Do you often see conservatorships, kind of partnered with trusts?
We do. It's sometimes people, will set up their own trust. Maybe they've gotten a diagnosis where they know that they might start having some mental acuity issues as they get older, so they want to do that estate planning ahead of time. And then when they get to a point where they can't handle their affairs, that's when another family member would ask to be their conservator so they can be taken care of when they can't take care of themselves. But that trust will survive because that trust continues on despite their disability.
Okay. So what is like the main mistake that you see when it comes to wills? Like if someone just took a piece of paper and started writing.
So the main mistake, you can do a will. Basically, if you're going to type up a will, for instance, someone came to me to do a will, you've got to meet certain standards for that will to be a legally valid document. For instance, it's typed up, you have to have it witnessed by 2 witnesses, you have to have a notary who will notarize those witnesses' signatures. So there's a lot of things you have to do, but an individual can do what's called a holographic will, where they handwrite it. Now, the biggest mistake there is they'll go type up a will themselves, and once they type it, because that holographic will has to be in their handwriting, dated, and signed. That's it.
It's one or the other.
But it's all in their handwriting and their signature. If you type it up and then sign it, that will is not valid without proper witnesses. So then that will, they think and I've had that come up, they think that they have done a holographic will, but they haven't. And so that will is not valid. So we go back to the last actual will they did, which is maybe not what they wanted if they did that tried to do a holographic will. So that's important to know.
Let's say someone, this was their first will. They've never thought about it before. All of a sudden, light bulb went off. They needed to put something together. When a will is invalid, what do you do in that case? Do you use that document as kind of evidence of what they wanted done, or how does that work?
So sadly you can't. So what ends up happening is that if that will is invalid, the court is forced to go back to the last valid will that they had, or if they didn't have a will, then in Tennessee we have an intestacy statute that says if you don't have a will, then this is how your things are going to be distributed, and we go back to that, which can get very complicated outcomes when maybe someone's lived a very long life, but a lot of people who would have survived them have died. Now we've got cousins and nieces and people splitting up their assets because there's no valid will that they probably never intended to get any of these things. And I think the one I had one recently where there's a partition action on some property where that same situation happened. And we had, I think, 40 people who had an interest in that property because so many this person had outlived so many people, and now all these lines had been created getting an interest in this property. So.
Wow. And is Tennessee per capita, or are we per stirpes?
So you can designate how if you want it to be per capita or per stirpes. In other words, in your will, you would basically say this is how this is to be divided. Essentially, if you were to pass away, and we go through that intestacy statute, if the next person in line was supposed to receive something, say you left it in your will to your brother, and you didn't say how you want that to be distributed if he doesn't, and that's important when we draft these wills. I always say, and people hate having these conversations, what happens if that person's not, what happens if your child does not outlive you? People don't want to hear that, but you've got to say what happens to their share. If you don't put that in there and that child has children, then those children would take equally, even if it's grandchildren you didn't want to get some, they equally would take that child's portion. And so that would be the default in Tennessee.
Okay.
So per stirpes, basically. Yeah. All the Latin terms we have to learn.
Oh yeah, we gotta love them. Love them. But this is an interesting one. How do I know if I need an attorney or whether I can handle a legal matter myself?
It's, well, the first thing is if the person who has a problem with you has an attorney, you definitely need an attorney. As I once told someone on the phone, they said, well, they have an attorney, but that attorney, I didn't think they did a very good job. And I said, well, they're still a trained killer. That's the way I look at it. And they went to law school and they have a law degree, and they're still going to beat you up in a courtroom if you don't have a lawyer. So I think in that situation, for sure, you need a lawyer. But I think if you feel like if you're dealing with someone and there's something you're really concerned about, I think you always need to call a lawyer. If there's a risk to you, your property, I think you need to call a lawyer because you don't want to do something that's going to, later your lawyer's going to regret you did that hurts your case.
Yes.
Which we see a lot.
Unfortunately.
We don't always get them when we want to get the cases, as you know. So
yeah. So with wills and with family law and things like that, you do have to have those really difficult kind of emotional conversations. How do you handle like boundaries with clients? And like what if a client wants your social media, or if a client, I don't know, wants to text you 24/7 or something like that? How do you handle that?
So and so I handle it probably different than I've seen some people. Some people just give out their cell phone and at any time they can be contacted. And I will not be honest, I have business clients that will work with because they understand those boundaries. Yeah. I think when you get into the family law side, I typically, they've got my email, which usually I'm checking most of the time, and then we have a lot of ways they can contact us, but I usually don't give out my personal cell because I think they're so emotionally invested, and I don't blame them, but something happens with their wife they're divorcing, or husband at 9 o'clock at night, the impulse, like calling your doctor if you had your doctor's cell phone. I equate it to someone who's pregnant and has their doctor's cell phone number. As soon as they feel weird, they're going to want to call, and understandably call that doctor, but it's not fair to that doctor at home with his cell phone that they're calling him every time they feel something weird. And that's the same thing when you're emotionally invested in your case. So I think I always create that little bit of that boundary, but be available. And I'll tell you a funny story. Chancellor Fansler, who used to be a chancellor here in Knox County, once had a client that called him on the weekend back when they had phone books. I heard this story, not from Chancellor Fansler, or someone else. It's a funny story. And so they called him at home at 9 o'clock on a Saturday night and said, all this has happened, and what do we do about it? And he said, this is reportedly what he said, well, meet me at the courthouse tomorrow at 6:30 a.m., of course, this being a Sunday. And his client said, well, wait a minute, the court is closed at 6:30 a.m., and he said, exactly, so why are you calling me at 9 o'clock on a Saturday night? Give me a call Monday, and we'll take care of it. And that's the truth, because there's only so much as a lawyer you can do if the courts aren't open. But that's a good story to illustrate that, like, there's nothing we can do about it tonight.
That's a good one. That's a really good story. We have gotten a few questions in our Facebook comments, so I want to take a minute to address some of those. So I guess just to preface one of these questions, what mental requirements, or what physician requirements are needed for a conservatorship? So essentially in Tennessee, when someone needs a conservatorship, there is a form affidavit that our legislature has put together, which is actually pretty well made, that gets to the point of what their condition is, what their physical or mental limitations are, because sometimes it's physical and mental, or either one. And they have to sign an affidavit under oath that they need a conservator. And so any physician can do that. It has to be a doctor. It can't be a nurse practitioner, unfortunately. Okay. I know people get treated, but the doctor still has to sign off for that. And essentially, what I have people come and go, my dad, I think he's got some memory issues. Sometimes it's a neurologist if he's already treating the one. Sometimes they got to get to a neurologist. But we send that affidavit. The doctor typically wants to see them again, and the doctor will then fill that out and say, yes, they need a conservator, or they don't. But you would file that affidavit with the court to then obtain a conservatorship and go through that process, because now the doctor is vouching that they need someone to handle their rights and their interests. And so that would be how you would handle that. And sometimes we also have the doctor say their mind is good. Sometimes when I have a will and someone comes into an advanced age, even though they appear to me to be very sharp and know what they want to do, if there's a troubled situation where they've got maybe a kid that they don't want in their will or something like that, we have the doctor say they do have testimony capacity. I'm confident that they can draft this will, so we future-proof it. Okay. So someone's not going to try to argue when they're not here to protect themselves that they didn't. So is there a limit, I guess? How many people can one person be the conservator for? So courts are loath and will do everything they can not to name co-conservators if they can. Sometimes it's unavoidable.
because you have people maybe who are not getting along, and of course you have the conservator. They have both their person, which is their personal rights to operate, make medical decisions, and do things with their body, go places, maybe be in a retirement home, and then you have their property, all their assets. And sometimes the court thinks if there's a child who's a caretaker and they live with them, they are better to be the conservator of the person, but maybe they're someone who's young, they're 25 years old, they don't know how to handle their finances, so we put the older brother in charge of the money.
Okay.
And so that's usually the split rather than having two Now, I've had co-conservators where it's like a husband and wife, where they've got a niece with a disability. That makes more sense because they're living with both of them. But the problem is when you have a lot of times both are required to sign, so that makes it very difficult. So
Okay.
because both have to be somewhere now. So.
What about the opposite? If one individual were to be the conservator for how many? What?
I never really thought about that.
What bouquet of conservatorships could we potentially have under Tennessee law?
So you could be a conservator for multiple people, obviously. Like if you got a set of parents, for instance, both mom and dad, and I have had that situation. It's not been often, but we file and get mom a conservatorship, and now dad starts having a problem. So now we've got to file, and they've got to be the conservator for both because both are still living and both have decisions that need to be made. And so you could do that. It's a lot to keep up with, though, because now you're responsible for that person. So there probably becomes a limit where I can't be Aunt Edna's too because I got too much going on with these two parents.
Okay. So conservatorship versus like your durable power of attorney, medical power of attorney, all of that.
Yeah. So now the big difference there, which it's important to have those, the durable power of attorney and the medical power of attorney. The medical power of attorney basically is where you have someone who makes decisions if you can't medically. If you were to get in a car wreck, if you were to have a disease where you can no longer make decisions, that person now can communicate with the doctor and make decisions for you. And those are very important to have. Typically, husband and wives will come in and they'll say, well, we just want to be each other's, which naturally the doctor is going to talk to the husband or the wife. But it's good to still have that because you don't know if you're in another country. You don't know if it. But I tell them, I go, well, who's the backup? And they go, we hadn't thought about that. So what if something happens to both of you? Now you can't be each other. So it's always good to have, if they don't have children, another relative, to have a child, maybe a backup to that child, because if that child's in another state, that someone needs to make a decision, and it's important to have those documents in place. Now, a power of attorney just allows someone to make the same decision you can. It doesn't take your rights to make decisions away. So you can revoke that. You can still do your own thing, but maybe your child has a financial power of attorney so they can help you pay bills. But you can revoke that anytime. A conservatorship really just takes your power to make your own decisions away because you can't do it anymore and gives that to someone else.
Okay. So addressing Miss Marty's question, she was asking about conservatorships for some of the homeless population that are under the care of a physician, kind of what that would look like.
So it's a really tough situation. I had a young lady call me, it's probably been a year ago, and you get those calls and your heart kind of breaks because there's things that can be done, but really the reality is it's not going to work out. She had a sister who was homeless, and the father had taken care of the sister, but he had gotten physically to a point where he'd struggled. She'd been on the street off and on, very physically strong, but not mentally. And she said, well, I feel like I should get a conservatorship for my sister, but the sister's violent, the sister's physically strong. And so I told her, here's the problem is you've now got to go file in court. You got to get her, they're going to order her to go to the doctor. And because you can't get to the doctor yourself. And they're going to order that, but who's going to get her there? The police aren't going to show up and take her. They're going to expect you to get her there. And you're going to go through this process. And once you're her conservator, how are you going to control that person who is physically strong but is not going to listen? And so that becomes a really tough situation, especially with our homeless, because they a lot of times return to those encampments. They return to the street even if they get off. And now you're legally responsible for them as their conservator. So if they go out and they do something, you've taken their rights away. But what happens if that person says, well, you should have done more to stop them from doing something? So that's a really tough situation. And a lot of times ETHRA and some of the community groups are better at intervening in those than maybe a relative who's now doesn't have a capability of controlling this person, who's very physically strong and physically active, but mentally is making really bad decisions. So,
okay, so in a situation, similar to the lady that you were referring to, What happens if the person is physically strong and they have enough to say no, we don't want to sign? What happens then?
So the court, and I've had that with someone elderly who refused to go to the doctor, the court will order them to the doctor, and really you've got to almost keep going back to court, and the court has to start kind of, even at some point they may have to order that, you have to go to the doctor, and that they give you the power to maybe try to get the police to intervene for their best interest, and it's a really tough process to do that, but you can do that, And they might even get committed somewhere in terms of being locked up for, especially drug use, for a period of time until, the judge or the court can assess the need permanently once they're maybe in there long enough if they need a permanent conservatorship. You can get an emergency conservatorship. That's certainly something you can do without a doctor's affidavit, but then the judge is going to want to see very quickly a doctor, see them, and find out, do they really need something permanently. So
very nice. Well, I learned a lot. Thank you so much.
Yeah.
But ladies and gentlemen, we are at the end of our half hour here on the Weekly Law Roundup. So just thank you again, Mr. Gillman, for being on the show. Do you have any shout outs? You want to throw your name and number out there?
No, it's that whole question we went back to, when do you need an attorney? If you think you need an attorney, you probably need an attorney. So call us, call Banks and Jones, good lawyers. And if we can't help you, we'll get you to someone that we have years of practice with who will help you. So,
all right. Well, It was great chatting with you. Ladies and gentlemen, you can find us here every Tuesday night from 6 to 6:30 on Praise 96.3 WJBZ. Again, this is K. Abigail Jones, stepping in for T. Scott Jones, and we will see you next Tuesday.
It was kind of stuck hanging down, and they were trying to grab it because it was in the way of the camera. And your dad didn't miss a beat. He goes, a little technical difficulty there. And he says, but you know what? Life's about technical difficulty. You got to get past it. Like immediately, he goes right. I'm like.